off the dribble, you're going to see how damn dumb the feds are and their quickness to put this shit out. So you got Bill, first assistant. You already know he ain't top rank no more. But here's where stuff gets interesting. This is a motion from the feds. United States of America plaintiff versus DeAndre Wilson, a.k.a. Lil Durk, a.k.a. Mustafa Abdul Malik, a.k.a. Blood. Y'all couldn't even fix that. Shout out to Durk all day for the obvious. Come on, man. Government's opposition to defendant Wilson's application for review of detention order. We just gonna get straight into it. And they talk about the filing and what it's based on and all this crap. Introduction. Defendant Wilson is an extreme danger to the community and a flight risk. He must remain detained during, pending trial. At its core, this case is about a well-funded and violent gang that promotes and commits violence for power, influence, and revenge. Defendant is charged with being a leader within the gang who recruited other hitmen to travel across the country to hunt and kill a rival. After defendant and the other hitmen arrived in California, they used 2 vehicles to track and stalk the rival from the night of August 18th until the murder occurred in the late afternoon on August 19th. Specifically, after tracking the rival to a busy gas station in Beverly Hills, 3 of defendants' co-conspirators opened fire with multiple firearms, including a machine gun, missing their intended target and instead murdering SR. This brazen and calculated murder, coupled with other aggravating facts before the court, including that defendant is alleged to have committed this murder while on pretrial release for another murder, so there are no conditions or combination of conditions to ensure defendant's appearance or the safety of the community. The government respectfully requests that the court affirm the magistrate judge's ruling and order that defendant remain detained pending trial. So I guess he done took the leadership position and the massive part of Lil Durk's Banks gang enterprise because now he's Lil Durk. Yeah, feds, fix that shit, man. But the more interesting point of everything is the feds are basically saying this is an open and shut case. The way that they wrote that, you can tell they're already screaming guilty, 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 guilty. Background. Defendant is charged with being a leader within a violent racketeering enterprise. The third superseding indictment, TS1, charges defendant and 3 co-conspirators with crimes arising from SR's murder. Murder in aid of racketeering in violation of 18 U.S.C. 1959A1, count 1. Conspiracy to commit stalking in violation of 18 U.S.C. 371, count 2. Stalking resulting in death in violation of 18 U.S.C. 2261A2A, B, 2261B1, count 3, conspiracy to commit murder for hire resulting in death in violation of 18 U.S.C. 1958A, count 4, murder for hire resulting in death in violation of 18 U.S.C. 1958A, count 5, in use, carry, and discharge of firearms and a machine gun in furtherance of a crimes of violence, count 6. 1. Defendant is alleged to be a leader of the gang. The TS1 alleges the following: defendant Banks formed a violent racketeering enterprise, i.e. the Banks gang enterprise, which nobody has ever heard of until the Fed said it, by recruiting prominent members and affiliates of the Black Disciples gang, including defendant Wilson, from different neighborhood blocks in and around the Chicago area. TS1. Defendant Wilson was a leader within the violent organization who recruited other gang members to commit violence on behalf of the enterprise. Indeed, anticipated witnesses and text messages will show defendant recruited 2 of the hitmen who traveled to California to kill defendant Banks and the enterprise's rival, TB, resulting in the premeditated murder of SR, count 2, 1 through B2 and overt act 8. This murder and other enterprise violence was fueled by defendant Banks' power, money, and influence, including payments for vehicles and guns to be used to commit violence and by using money to incentivize murder and other violence against rivals. Specifically, the TS1 alleges that defendant Banks would place bounties on individuals that he and other enterprise members wanted to kill and reward individuals who were willing to commit violence against defendant the enterprise's rival. For example, based on an alleged bounty offered by defendant Banks and enterprise members, co-conspirators 7 and 8 ambushed and murdered victim 2, a rival gang member, as he left the use the Youth Peace Center in Chicago on January 27, 2022. After the murder, co-conspirators 7 and 8 explicitly discussed obtaining payment from defendant Banks and the Enterprise. Co-conspirator 7 traveled to meet with the Enterprise members, including defendant Banks and Wilson, and co-conspirator 7 then subsequently displayed the money he received for the killing in a social media post while playing defendant Banks' lyrics about stalking a rival or op. Materially, as of May 20, 2026, co-conspirators 7 and 8 have pleaded guilty to committing the bounty murder. United States versus Montgomery Wilson. And then it goes on to say, change of plea hearing for defendant Montgomery Wilson. Montgomery Wilson plea agreement 186. And then change of plea hearing for defendant Powell 187. Then it says Powell plea agreement. So now we know that there's witnesses, there's text messages. There are people who are going to say, he recruited me. The way that that's written, they're basically saying they're going to be able to put up a witness to 100% emphatically say, yo, this man is the reason why I was here. He came and he got me up out the trenches. Then it gets more treacherous because they say he was always the one handing out the paper. Defendant recruited shooters and was a direct participant in SR's ambush killing. On August 18, 2022, defendant and his co-conspirators learned that TB was in Los Angeles. In response, defendant allegedly recruited others to commit the murder and then traveled to California to kill TB. After arriving in Los Angeles, defendant and his co-conspirators used 2 cars to track, stalk, and attempt to kill TB as TB drove around Los Angeles with his entourage, including SR, after hours of stalking TB and his companions. 3 of the defendant's co-conspirators cornered TB at a crowded gas station on the afternoon of August 19th. There, the co-conspirators ambushed TB's vehicle and fired multiple rounds towards TB's car, striking and killing SR. Surveillance video shows that less than 45 minutes later, around the time when SR's body was being removed from a vehicle, defendant was ordering food and laughing with his co-conspirators. See docket 420 at 2, screenshot a video depicting defendants Wilson and Lindsay. After ordering food, defendant and 4 of the direct participants in the murder traveled to San Diego to catch a flight back to Chicago, nigga. Defendant was on pretrial release for a separate murder when the co-conspirators allegedly murdered SR. As set forth in the United States Probation and Pretrial Services report, defendant was on pretrial release on Illinois state murder charges when he is alleged to have committed the Los Angeles murder. Then, after defendant was acquitted of the Illinois murder charges on July 6, 2023, defendant Banks celebrated telling defendant Wilson and Enterprise members, D-ski, defendant Wilson beat his murder, he gonna be more dangerous. Shit. Consistent with this text message, defendant was arrested 12 days later by the Chicago Police Department and charged with multiple weapons violations, including aggravated unlawful use of a weapon. Those charges are still pending. Defendant's criminal history also includes a series of arrests for gun and drug-related crimes, among others, and misdemeanor convictions for illegally possessing a gun and for trespass. It's funny they say that because in them saying that shit, you also knew another judge had gave him bond for murder and all of that stuff. So while they're trying to add more salt and add more dirt on there, I would easily argue, well, a previous judge knew that and did all of this shit and still let him go. And he ultimately beat the charge. So y'all can say this shit and he has a propensity to do whatever, and all this stuff. Even though he went where he went, he came right back. And that's the lame-ass games that the courts play. And it sucks because an attorney knows that they're going to say these things, but they can't be the ones to bring it up. But you can in front of common thinking people. Let's get out of here with this last part. Defendant is twice ordered detained pending trial. After 2 separate hearings, Judge Ardero ordered defendant detained based on the danger to the community and flight risks. Then it goes on to say Judge Ardero determined defendant was an ongoing danger based on the nature of the alleged criminal activity, defendant's criminal history, including the pending firearm offense in Illinois, and defendant's unemployment status. So you ain't even got a job. You just out here shooting shit and killing shit and selling drugs and getting caught with guns and catching fights, whatever. Judge Ardero also found defendant was a risk of non-appearance based on his lack of ties to the Central District, his unstable residence, his unemployment status, and his recent international travel to the Dominican Republic in February 2024. Why is these niggas always going to the DR, bruh? What is up with y'all? I don't know, bruh. Anyways, 3, argument. Defendant is presumed to be a fight, risk, and danger. Although review of the magistrate's court's detention order is de novo, this court is not required to start over and proceed as if the magistrate's decision and findings did not exist. A defendant must be detained pending trial. We ain't really tripping on all that shit and everything, but basically they talk about the Bail Reform Act, and then it just basically goes on to say, yeah, he's supposed to be there. This is not a close case. The evidence of defendant's guilt is significant and includes anticipated testimony from multiple witnesses, text messages showing defendant recruited others to commit the crime, location data showing defendants and his co-conspirators stalking a TB and SR, videos showing defendant and co-conspirators shortly after the murder, and other evidence establishing defendant's leadership role in the alleged gang enterprise. Defendant's willingness to commit murder while on pretrial release for a separate murder demonstrates a complete disregard for the law and establishes that he possesses an extraordinary danger to the community and that no conditions can assure his appearance for trial in this case. Defendant's criminal history and the punishment he faces further warrant continued detention. As Judge Adero reasoned when finding defendant was a danger to the community, defendant's criminal history further establishes his dangerousness. Defendant has been arrested 19 times, including this case, has misdemeanor convictions for illegal gun possession and trespass, and has a pending felony case in Illinois. Defendant's criminal history, taken together with the aggravating allegations contained in the TS1, warrant his continued detention. So, yeah. Moreover, defendant faces a lengthy prison sentence, mandatory life imprisonment. The severity of the potential penalty underscores his risk of non-appearance, which, if we're going to be honest, yeah. Anyways, conclusion. Defendant's release would possess a grave risk to the safety of the public and potential witnesses in this case. No condition or combination of conditions can ensure defendant's appearance or mitigate his danger to the community. The court should order defendant detained, and they pretty much will. It is beyond difficult for a judge to sit up here and say, yo, he was not good to go, and now he's good to go based off of a more horrible superseding indictment. The third one is the worst one type of shit. Yeah, he's not getting a bond, but the way that they're playing this, they have to. I've seen too many times where people are like, oh, the courts, the people are being paid and all this shit and all that. The lawyers are running, they know it's not going to work. You're not doing it for any other reason for the chance that it may. So when people are criticizing these motions and people are criticizing them trying to get a bond, the other alternative is why the hell not? It's better if you know you couldn't, opposed to you believing you can't. Everybody has the answer once the answer comes out and you go, yeah, I do that shit. We know he's not going to get a bond, but shit, it's worth the chance. And by them doing this bond shit, they are forcing the feds to reveal their hands. Because at the end of the day, this is simply a case of Lil Durk being this freaking monster who could have people shot at in multiple states and all this stuff and everything. But if that's the case, if it's the case, right? Why is it that none of this shit couldn't have happened before? So there's that, the Stephon Mack shit. Are we even sure that Stephon Mack has something to do with D-Thing? Because we're no longer seeing that shit in there. There's nothing that shows that I've seen as of late, and maybe I just missed it, where they say, oh, Stephon Mack is alleged to have killed Lil Durk's brother and all this shit, and we did an investigation and all of this and everything. If Drew Finland or Brian Steele or I can't think of her freaking name right now, if they can find the connection between Stephon Mack and the other two guys, why they were beefing and why they killed him and a motive and all of this shit, bro, I am telling you now, that's going to blow this shit wide the hell open. So that's the number one thing that I believe that they had to do is they had to get some connections down there in Illinois and thoroughly vet all this shit and try to come with it that way. Because now the courts are going to have to push this shit back. We're not going to get a Lil Durk trial until 2027. He's going to spend 2 years in jail. Federal jail, but still jail nonetheless. So I don't know, man. It's just to me, it's it's so stupid that you're going to see the evidence doesn't show Lil Durk shooting nobody or none of that for the Atlanta shit. The other Atlanta shit that happened in Black Shear and all this shit. All that's going to be is hearsay, he said, she said, and all this shit. It's just going to come down to concise questions because the text messages, they have threads. So you have to wonder when Durk and when his crew and when his team, when they were talking in the thread. And once again, how is it everybody else is getting paid, music opportunities and all this shit, but everybody else who allegedly killed somebody, they didn't get any of that? But Durk would pay the dude who allegedly clipped the dude who allegedly clipped his brother? All right. And then the theory behind that is, oh, we just knew to kill dude because Lil Durk already put it out there in the streets that he was going to do that shit. Yeah, all right. Believe what you will, man. Subscribe, turn the bell to notify, share to keep your people aware. We are 10K from giving these two things away. Make sure you like every video, comment on every video, and share every video. If you can, hype it up like you like this stuff. Y'all, let me know y'all got their thoughts on this one. But Pooh Shiesty's co-defendants say Feds is lying. Click right here for that video or click right here for the playlist, and I will catch y'all in the next one.